Good afternoon, everyone, and welcome to the Travel Vault webinar. Apologies for the slight delay there. We had a few technical issues. Today, we're going to be taking a short break from the coronavirus to focus on Brexit instead. My name is Christina Brazier, and I'm Operations Director of the Travel Vault. I'm joined today by Martin Alcock, Director of Travel Trade Consultancy, and Luke Golding, Senior Associate at Kemp. It's hard to believe that we've been talking about Brexit for over 4 years, and we still don't have absolute clarity on what will be happening after the transition period. However, there is apparently still time in theory to finalise a deal before the 1st of January, and Martin and Luke will be taking us through the key points that we do know and that we need to consider in preparing business and customers for the changes. As usual, all attendees are muted for a better sound quality, but we do welcome questions. And if you'd like to put one to our panel, please use the Q&A function at any time. However, please note that we won't be covering any employment, HR or visa related issues today, but we do know that you'll have queries on this. So please email them to Lucy and we will get answers from Luke's colleagues at Kemp Little for you. If you have already sent a question in, we will ensure that this is passed on. Please also note that we'll be recording the webinar as usual, and it will be available on our YouTube channel later today. So Martin, if I can hand over to you first to take us through your presentation, that would be great.
No problem. Afternoon, everyone. Let me just share my screen. So if anybody happened to be play from the start. Hopefully you can see everything there. Play from the start. There we go. Yeah, if anyone happened to be on the ABTA Brexit webinar yesterday, then this might all seem very familiar. If you weren't on the Brexit webinar yesterday by ABTA, then the jokes yesterday were far better. So look, it's a pleasure to be here again and a pleasure to be talking to everybody about something that other than COVID, frankly. Because that's pretty much all we've talked about for the last 8 months. I think if you go back 12 months or so ago, and actually I was looking through some notes around this time last year, you know, Brexit was pretty much last November, the worst thing imaginable. And so I think if COVID's achieved anything in the last 8 months, it's that Brexit doesn't really seem like such a big issue anymore. I suppose it is a big issue though, right? There's lots of changes coming our way. There's lots more negotiations to go. And I think, you know, I think there'll be high temperatures between now and Christmas, lots of sore headaches and an inevitable bad taste in the mouth. And so maybe now that Pfizer have got a bit more time on their hands, maybe they could come up with something to sort that out. This week in the news has been held out as a pivotal week, I suppose, for the negotiations. And you know, bear in mind we're now Thursday and still haven't heard anything. Then maybe that's not quite the case. I think there was a lot of speculation, though, going back to last weekend, that this weekend we would see either a breakthrough or a breakdown in the talks. Reassuring to know that our glorious leader is now out of self-isolation and ready to leap into action and dive into the negotiations to save them if it's needed. And I, for one, have every confidence in, from everything I've seen from the government actually over the last 8 months, that there won't be any issues and common sense will prevail. I suppose it's important to point out, though, that, you know, for all the speculation around Brexit and what may or may not happen and what will come into force on the 1st of January, really worth remembering that our government's chosen approach on the negotiations means that in many areas the difference between a deal and a no deal are you know, very little. You know, ultimately, I think if there is a free trade deal to be announced, and I really hope there will be, I think it will be, you know, barest of bare bones deals. It will really be about goods and import and export primarily, very little on services. And I think when, you know, what's been painfully plain to see for us and for many of you on this call over the last 8 months is that, you know, our government don't hold travel in a particularly high regard and certainly haven't bent over backwards. And so no reason to believe that there will be lots of special travel provisions in any deal if and when that does materialize. So obviously that's kind of devastating, but look, on the plus side, it means there's a bit more certainty about what we can expect, which means we can actually get going and start planning for some of these things. So I think, I suppose the other thing to point out is there are some areas that are a bit more fluid, but if the last 8 months has taught us anything in business, it's an ability to be reactive and the ability to change to conditions as they change. So hopefully that stands us in good stead. So happy to take you through over the course of the next hour or so some of the real insights. Thankfully, Luke's here to deliver that bit, and I'm just going to do some, I guess, initial high-level practicalities and cover off a couple of areas. The first thing really is just on this slide highlighted, I guess, 11 areas that you should really be considering, and Luke's going to touch on some of these. I'll mention a couple. Lucy's already mentioned that a few of them we might have to park, particularly around the employee side of things. But we'll cover off some of these areas in a bit more detail. But really, these are the sort of main areas that you should have in your mind as you're going through this. Of course, depending on the type of business that you run, the impact of some of those 11 areas will be very different if it's outbound versus inbound, and to a lesser extent if you're entirely domestic tourism, then there'll be other consequences. But I think the impact, it's hard to imagine any business really not being impacted, certainly in travel, not being impacted at least by one of those areas and not having to do at least something, whether that be just even something minor in a contract or something in your supply chain. I think it's really going to hit all of us. The first area I just wanted to touch on is TOMS. So after having waited for ages for any sort of clarification on what TOMS might look like, we now do finally have a bit of an indication and a bit of a steer, but not all of the questions. This is literally hot off the press, the notification that ABTA has been working on with HMRC to give clarity on how TOMS will be treated from 1st of January. It only came out today, so I'm still trying to get my head around it. And I think we'll try to, I know TTC are going to put out some more on this. I think early next week, we're aiming to get something up on our LinkedIn page with a bit more detail. But I'll run through initially my understanding of it. Happily will take any questions and answer what I can, but might have to take some away. But so very broadly, what we do know is that non-UK holidays, this is confirmed, will definitely be out of scope, so will be zero rated from a TOMS perspective. So effectively the percentage falls to 0% from the 1st of January. So something that we'd suspected, and on the face of it, good news, because that's on a departure date basis. So any overseas holidays that depart after 1st of January would instantly become zero rated. The bits that we don't know, and there's quite a few questions that we're still trying to get to the bottom of. I think in the first instance, it's this sort of reciprocal point. If it's zero rated from our perspective, well, what happens to the other side of the transaction? Does that mean that each of you has to then go and register for VAT in every one of the EU member states in which you send customers to? That's a question, and we're still waiting for clarification on that point, but very possibly that might be the outcome. I think another area is considering, well, how do you go about apportioning the margin, or even on your UK holidays? I think from 1st of January, it'll be 0% for all of the non-UK holidays you sell. But for the UK holidays that you sell, there's a job to apportion margin by the different components of those holidays. And obviously there's a lower VAT rate on certain aspects of that accommodation, etc. for now. Higher margin on transport. There will be some mechanism agreed to be able to take advantage of that lower rate, but it will mean apportioning your overall profit margin by each of those different elements. Still a little bit unsure on what that looks like. I think there's a question mark over financial year ends that straddle December. So if you've got a financial year end of the end of December, then it's very, very clear that you account for TOMS under the old rules up to then, and then the new rules from the 1st of January. But of course, for everybody whose financial year end straddles that period, then you're effectively having to account under two different schemes. There's a number of ways that could work out, whether you apportion margin or very simply by sales and cost of sales in the run up to December and then January. Again, waiting for a bit of clarity on that point. And I think finally there's this idea of the provisional percentage. So when you're calculating your TOMS liability, usually you would use a provisional percentage which is based on your historic trading, and you would apply that to your current year's trading, and then there would be a true up calculation in the final quarter. And I guess that provisional percentage would seem unfair if you've got a blend of UK and EU holidays, and so you're basing your future calculations on a now out-of-date provisional percentage would see you paying a much higher liability next year. So some question marks over how that can be dealt with. I think in some cases it might be a bit of a moot point, because we understand the provisional percentage certainly for your EU sales would be zero. So if all you do is sell EU holidays, then that's clear. Where it gets a bit more complicated is if there's a blend. I guess the other way you might look at it is lots of our clients in TTC aren't expecting to make a profit this year, and so their provisional percentage might well be zero anyway next year. But some question marks over the technicalities of how that's going to work. But I'm not going to say any more on Tom's for now, because there are people in my team far better qualified than me to answer them, and they'll be working on something to put out, like I say. I guess just want to say a few words on currency. I think when it comes to exchange rates, I think you've got to be prepared for a really bumpy ride over the next few months. This slide here, you can see the euro sterling rate going back over 5 years. And obviously we saw that big depreciation in at the time of the referendum in 2016 when it dropped a huge amount. And ever since then, it's operated in this fairly narrow band of 110 to 115. And I think the danger is that complacency can set in and we can sort of assume that that's where it's going to stay. I think really to understand what the impact might be of the next few weeks and months of negotiation, you've got to really ask the question, what is already priced into that rate? I think the conversations I've had with people who work full time in the currency world are saying, well, there's so much emotion that's driving exchange rates right now, just as they are the equity markets. I mean, if you look at the equity prices of airlines and travel companies, when the Pfizer vaccine news came out a couple of weeks back, they all leapt by about 40% in some cases. And that's nothing to do with the fundamental underlying values. It's just the emotion driving the investments. And so I think you can see that the same has been happening in the currency markets. And in the weeks ahead, as the negotiations proceed, inevitably there will be brinkmanship and crisis that will lurch from one to the other. I think you can expect major swings in this rate. So obviously COVID has a bit of an impact here though, because on the one hand, there's going to be very little booking activity. I think we have to face that reality. Normally in a normal year, you would be expecting to gear up for a very big January. That's a big booking month for holidays. And I guess the currency problem would be a much harder one to manage. And so maybe the fact that there's a smaller number of bookings just dampens the impact of that volatility of currency. But I think the flip side is, and again, it's really going to depend on your business and how your costs in other currencies fall and how fixed and committed they are. But the flip side is we have no idea what those trends and profiles are going to look like over the next 12 months. And so your usual patterns of how you might layer up hedging to cover off those liabilities are totally out the window. And so I think for me, what's fundamental in all of this is you have to optimize for flexibility. So that means putting in place hedging currency management arrangements that you can exit from. Sometimes there's a bit more of a cost to that, but if there is another spike in cancellations, let's say because there's a third wave or there's longer rollout of the vaccine than is expected, or bookings don't materialize, I think you do have to be in a position to make sure you can exit those arrangements. Another practical consideration, and I think it's something that is overlooked because it's frankly a bit boring, is the way you capture your data and the systems that you use to hold your customers' data, because that actually underpins probably 2 or 3 of those areas in those 11 that we set out. So for example, if you're selling holidays in overseas territories, and you won't be able to do that come 1st of January without licensing in a separate territory, you're going to need to be able to pull out the necessary data to sort out those applications. Similarly, if we do end up having to register for VAT in different member states, you're going to need to be able to report by territory, by destination, and even, and I think Luke is going to cover this area from a data protection point of view. There's a decision to be made about whether the UK's data protection rules are acceptable to the EU, and that may form part of a deal. But if there's not, and there's ultimately different rules about how you collect data from the EU customers versus UK, you really need the systems to be able to identify that. And one of the problems we see all of the time, even with some humongous companies actually, is that their data just isn't held in a way that you can easily report that. So I think if you're in a bit of a downtime or you're shopping around for a new system, certainly something to just consider is, can you break out that customer data and can you store it in such a way that allows you to report? And finally, I think everybody by now should have their own Brexit risk matrix. I'm a firm believer that there's no problem in this world that can't be solved with a spreadsheet, as you probably have heard me say before on countless of these webinars. And so if you don't already have one of these, and with Christmas just 30 days away, it's my pleasure to offer you a free Brexit risk matrix. there's a hyperlink on the bottom there, and actually feel free to go and download that now. And Santa Claus and his little elves will email that straight to your inbox. I guess the purpose of this, and it's not a panacea, it's not going to solve all your problems, but really it's aimed to, I guess, in a systematic way, help you just go through your business and figure out where are the risks, where are the potential issues. It's a very simple, but it basically breaks down each of those 11 areas that we've talked about. It helps you kind of factor down what the risks are, identify likelihood or importance to come up with an overall risk rating. And then I suppose most importantly, you can put some action points together and figure out who's responsible for resolving the issues. So I think, during the course of the rest of this session, Luke is going to touch on some of these areas. And so if you're quick, you could maybe get this open now and fill it in real time, like one of those, choose your own adventure stories. But if not, feel free to grab it later and start to fill it out and tailor it for your business. Remember that you do need to tailor it. We've populated it with some example risks and example areas, but really it needs to be you looking at it from the perspective of your business. So that's it for me. Just a couple of quick plugs for other resources. If you haven't seen the government's transition site, it is quite useful. You can go through a series of self-assessment questions, and it will kick out a list of the key risk areas that you need to be aware of and the things that will impact you. And the other thing is the TTC's LinkedIn site and website. Actually, if that's all right, I'll plug that one more time. You might have noticed there's been a little QR code on the bottom of each of the slides, but just in case you didn't, there's a nice big version of it. That will take you to our site. If you sign up and follow that, we're trying to put out as much as we can as we're learning about it. And so over the coming weeks and months, there'll be more on Brexit or on TOMS, and hopefully it helps. So that's it from me. I'm going to hand back to Chris, I think.
Thank you. Thanks, Martin, and thanks for sharing those useful tools. Actually, I think Lucy has put a link to the matrix in the chat function for anyone that wants to click on that. So thank you for taking us through that. We'll have some questions for you later on, but first I'd like to hear from Luke, who's going to be taking us through some of the legal considerations. So Luke, we'll hand over to you.
Perfect. Thank you very much, Christina. Yes, hi everyone. So firstly, let me just set up my screen. Hopefully you can all see this, but please do shout if not.
That's perfect. Thank you.
Fantastic. Right, brilliant. Well, as Christina mentioned at the beginning, my name's Luke, and I'm a senior associate in the travel practice at Kemp. And what we're going to do for the next 20 minutes or so is take a look at some of the impacts that Brexit might have on your business from a legal perspective. So we're going to focus on three key issues in this section. We're going to look at the impact that Brexit may have on your commercial contracts and the steps that you can take now to prepare for that. We'll take a look at how Brexit might impact the operation of the package travel regulations. And finally, we'll consider what measures you might need to take from a data protection perspective too. So if we start by taking a look at your commercial contracts, there are many different ways in which Brexit has the potential to impact your commercial contracts. And note that while this will primarily be the case for contracts that cross borders, so where you are contracting with a party that is established within the EEA, for instance, the impact of Brexit isn't limited to those contracts exclusively. And so it is worth reviewing all of the contracts that your business enters into or has entered into to determine what the impact might be and what risks you might need to take account of. Now, some of the impacts are rather more general or overarching. So for instance, Martin just touched on the fact that exchange rates might fluctuate and there might be a lot of volatility in exchange rates come the end of the transition period. And so that's certainly something to take into account. You know, we saw after the 2016 referendum that they shifted quite significantly. And it could be that that is the case again come the 1st of January, or it could be a more gradual process whereby they continue to remain quite volatile for some time to come. Alternatively, the regulatory regimes in the EU and the UK could diverge. And this may mean that UK businesses selling to the EU may need to comply with different regulatory regimes and different conformity assessments and vice versa. And those events and many others could ultimately lead to contracts becoming loss-making or more difficult to perform. However, it's unfortunately unlikely that the parties to a contract will obtain relief from the consequences of those changes in the absence of express provisions in the contract to cater for them. So for instance, it's unlikely that a party will be able to rely on a standard force majeure clause to seek relief from those sorts of risks. While force majeure doesn't have a precise meaning under English law, relief as a result of force majeure is normally limited to obligations that are rendered impossible to perform, whether actually or legally, as a result of the force majeure event. And so force majeure is unlikely to assist where the contract simply becomes more onerous, unfortunately. That said, the position might be different if Brexit makes the performance of a contract impossible, or removes the very purpose of the contract. Force majeure, or the concept of frustration, may assist in those circumstances. However, they are likely to be relatively rare, I would have thought. So that's why it's very important to review your contracts and see what your risks are, and what options you might have to address those risks. So when reviewing your contracts, as well as considering the general impacts and the general risks that I just mentioned, there are a number of very specific clauses that are worth focusing on too. And as Martin mentioned, if you're going through a process of auditing your contracts, it would be very useful, I think, to look at these clauses that I'm about to mention, particularly in each contract review that you do. But while the impact of Brexit on any contract will turn on the facts and the content of the contract, as I say, if you're developing a crib sheet, here are the points to focus on as a general across all of them. So the first point is quite technical, really, and it's what are the definitions in the contract around the applicable laws, and what are the references to the EU and to EU laws too. So for instance, if we consider references to the EU itself first and foremost, an issue to consider is whether references in a contract to the EU will continue to include the UK after Brexit. Now, the answer will depend on the purpose of the clause and the context in which the reference is used. So for example, it might be used to define the territorial scope of a right or a restriction, such as a trademark license that covers the EU, or it might be used in a restriction on transferring personal data outside of the EU. And the starting point when assessing this is to look at the express terms of the contract. So if the contract defines the EU by reference to its member states from time to time, then that would strongly indicate that it won't include the UK after Brexit. In contrast, if the contract instead takes an approach whereby it defines the EU as a list of the countries that were members of the EU at the time the contract was entered into, and that list includes the UK, then that would indicate that the contract would still continue to include the UK in that context. So as I say, the best way to protect against this uncertainty going forward is to expressly, in each case, define whether the EU should include the UK after Brexit, or indeed to list the countries you want the restriction or the other provision to apply to generally. So that was references to the EU itself. It's also worth taking a close look at any references to EU law. So for example, one term that you often see feature in a contract is a definition of applicable law, and that will sort of generally define the applicable laws that one or both parties need to comply with. And it's worth taking a look at that definition and assessing whether or not it's currently UK or EU law, and whether any changes need to be made to reflect that. Similarly, where you have references to EU law in the contract already, how do you want to deal with them going forward? Do you want them to be references to EU law frozen in time, so that they apply to the position as it is right now, or at least at the end of the transition period? Or do you want the contract to essentially be able to continue to evolve to accommodate any changes in those EU laws going forward, notwithstanding the fact that the UK itself might not need to comply with them? And then just another quite technical point, but look at the wider references to laws generally, and expand the wording, consider expanding the wording which updates references to statutes. So it's clear that any references to UK laws in the contract will include any Brexit-related amendments that might come over the course of the next few months. So that was a fairly technical legal point around definitions and applicable laws. The next one's a bit more commercially friendly, and it's another clause, a set of clauses that you might want to consider are those relating to payments and charges. So a very basic point to look at here is, what is the currency for payment under the contract? Is it pound sterling? Is it euros? And are you happy with that still being the case going forward? If you have a particularly strong commercial position in any contract context, you might want to consider allocating the risk of currency fluctuation. So for instance, if there is another large swing and if the pound becomes much weaker in the coming months, do you have the commercial ability to amend the contract to adjust the pricing model, or in other ways share the burden and share the risk of that currency fluctuation between the two parties? You'll often see a clause in contracts as well, particularly longer term contracts, which looks to sort of increase the price usually on an annual basis to take account of the fact that the contract applies over a long time and the real rate for the services or the goods that you're purchasing will change over that time, and often they're indexed against a particular index. So have a look at that if that's the case, and just ask yourself whether the index used is still appropriate. Is it a UK one? Is it an EU one? And in either event, is that something you're happy to continue following going forward? And then a wider point really, do you require any credit checks or credit references from any of the other parties that you contract with? So for example, any suppliers who you work with? If so, again, just review those provisions to determine whether the mechanisms for those credit references and those credit checks will still be relevant and will still be correct going forward. Another issue to consider when you're looking through your contracts is whether you need to impose any new warranties or any new obligations on the other party to the contract. So for example, this might be to reflect new or amended compliance obligations or different regulatory bodies, laws or standards that might apply going forward. Now, unfortunately, in the context of Brexit, it might be that those requests or those changes need to be made against the UK company, particularly when you're providing a service into the EU. So they might get raised on the other side of the fence, but nevertheless, it's worth looking at the contracts that you have in place to make an assessment of whether they're still fit for purpose in terms of the obligations they impose on the other party, and whether you need to protect yourself by adding anything else into there. Now, two clauses which are, again, quite legally technical, but which I think are very pertinent in this area, are the choice of law and the choice of jurisdiction clauses. So if we look at choice of law first, this is the clause that essentially dictates what laws will apply to the interpretation of the contract. So for example, you'll usually see a clause that says this contract is subject to the laws of England and Wales. Now, if it's England and Wales, it might be that you're quite happy with it being England and Wales, and it might be that no further changes need to be made going forward. Certainly, there's no reason to think that English law as a governing law to a contract will be any less attractive going forward as it is now. But if that's not the case, and if you instead perhaps had a weak commercial negotiating position with one of your suppliers or with another third party, and agreed to allow the laws of an EU member state to apply to the contract, perhaps in the consideration of, well, they'll be broadly similar to the UK in many respects, and so we're somewhat comfortable with following that approach to the contract. Well, that might no longer be the case going forward. And so you might want to have a look at that, whether you're happy to still allow the contract to be bound by the laws of that EU member state, or whether you want to push for any changes to be made there. Now, as I say, going hand in hand with choice of law is choice of jurisdiction. So the clause typically deals with 2 points at once. It says this contract will be subject to the laws of England and Wales and subject to the exclusive or non-exclusive jurisdiction of the courts of England and Wales, or any other third country. Now, what this clause does is determine how disputes will be handled under the contract. So for example, if the contract said it'll be subject to the exclusive jurisdiction of the courts in England and Wales, either party who wanted to raise a dispute with the other would have to do so in the English courts. So after Brexit, exclusive and non-exclusive jurisdiction clauses will still be effective in the English courts, so no problems relying on them domestically. But the position in the EU courts will be slightly different. So for example, what the EU member states will do is they'll give effect to exclusive choice of jurisdiction clauses after Brexit. So if going forward you put in your contract, any disputes will be subject to exclusive jurisdiction of the courts in England and Wales, they'll still be effective for any new contracts going forward. But what EU member states might not do, and it's a might because we don't know this for certain, but what they might not do is give effect to exclusive choice of court clauses that were agreed before Brexit, or non-exclusive choice of court clauses whenever they are agreed. And so a non-exclusive choice of court clause is essentially more of a preference than a binding obligation on either party. So in terms of practical things to look at going forward, you want to have a look at the choice of court clauses that you have in your contracts at the moment, figure out whether you're happy with them as a general point and whether you need to make any changes. And so changes might be, if it's an EU member state, bringing it back to the UK if you have the power to do so, or in some way refreshing the party's commitment to agreeing to be bound by the exclusive jurisdiction of the English courts, if that's what you already have in place and that's what the parties wish to continue to be bound by. Now, all that being said, one wider point to consider is that it's likely to be harder to enforce UK judgments in the EU post-Brexit. There's a strong possibility that enforcement in other EU member states will be subject to national procedural laws in those member states, and that those laws might be less streamlined and might afford less favourable treatment to English judgments. So if an English judgment that if you have a dispute going on at the moment where you expect to obtain a judgment, and if it's one that you're likely to need to enforce in the EU going forward, or indeed you can consider this in a hypothetical point of view for your contracts going forward. But if it's likely to be the case that you'll have English judgments that you want to enforce in the EU, the conservative approach would be to do either or both of the following things. So one, assume that national law will apply and take local advice on the implications of enforcing an English judgment in that EU member state. Or two, and this is more the case for new contracts going forward, but you could consider using arbitration instead. And so saying that the contract, any disputes under the contract will be bound to be resolved by way of arbitration rather than a court claim. And the reason for this is that arbitration is likely to be unaffected by the UK's transition out of the EU, as arbitration law is generally regulated by national law and by the New York Convention, which is a non-EU international instrument. And so an arbitration award made in the UK should remain recognised and enforceable in EU member states, and indeed vice versa after Brexit. Final practical point to consider there is if you are contracting with another party that's outside the EEA and you are saying that disputes will be resolved by the English courts, you might want to consider requiring the non-UK counterparty to appoint a UK agent for service. Basically what that means is it's going to be more difficult to serve proceedings on EU companies after Brexit. And so if you can get the non-UK company to appoint a representative who is authorised to receive service of legal proceedings, it will make it a great deal easier for you to actually progress claims if they ever arise. So, aside from the specific clauses that I just mentioned, there are a few wider issues that are worth paying a quick bit of attention to too. The first one is just to check how whether there's any valuable know-how that's already captured and whether or not it's accessible and not locked up in suppliers. So to sort of put some skin on the bones there, when contracts end or companies go insolvent, vital information is usually lost. So for example, don't allow valuable data about products, about services, or about customers get locked up in a supplier who has ceased to trade or terminated their agreement. Brexit planning with suppliers really should involve looking at how business critical knowledge, standard operating procedures, and information will be captured, stored, and disseminated, especially in the event of insolvency or a sudden inability to work across borders. And it might be that you need to include in new contractual terms in your contracts to cover those points off. Another issue to look at is whether you have any ongoing disputes and whether they might be impacted by Brexit. So for example, by a risk to the challenge to the jurisdiction clause, as I just mentioned, or more difficult enforcement. And if you do have any disputes that might be affected in that way, consider accelerating that dispute or consider accelerating the settlement of that dispute. Now, there's not a huge amount of time to do that, but it's worth paying some attention to. On a wider note, I know that matters aren't really straightforward with insurance at the moment either, but if you see any sort of likely or obvious risks or losses to your business as a result of Brexit, it's always worth having a look at your existing insurance policies and seeing whether or not you'd be covered for those losses if they arise, and what steps you might need to take to claim if you are covered. And then finally, this isn't really a point that I think any of us really want to consider in the middle of Brexit and COVID. But if you're going through this whole process of reviewing your contracts, you might just want to have a look at whether or not it's worth future-proofing them. So making any amends of the types that we just mentioned to guard against any future changes. So whether it's another EU member state deciding to withdraw from the EU, or whether it's Scotland deciding to withdraw from the UK, is it worth making a few subtle changes to the definitions and the references in the contract now to account for that? So they were the various impacts that Brexit might have on your commercial contracts. But the options available to you to manage contractual risk are likely to be unique to each contract. So some contracts will contain a significant amount of flexibility. For example, they might be terminable at short notice. They might be purchase contracts with no volume commitments, whereas others might contain more long-term commitments that are difficult to get out of. So flexibility can be good or bad depending on your position, but it's an important factor to bear in mind when determining whether the contract should be left as it is, whether it should be amended, or whether it should be terminated. So in terms of the practical steps that you can take now to assess the potential impacts and to figure out what options you might have to cope with them, if you haven't done so already, I think it would be very wise to perform a contract audit really as soon as you can. And in terms of what that might actually look like in practice, I'll sort of run through a bit of a framework that you can follow now. So the first step would be to consider the contracts throughout the whole supply chain of your business. So for example, this would include the contracts that you have with your suppliers, and then also considering any contracts that they may have with their own subcontractors. And there, what you're looking at doing is assessing those contracts for suitability and asking suppliers about their own and their subcontractors' preparations for Brexit. You know, if you have any concerns about whether they're doing what they need to do, put the onus on them to reassure you that they're taking the right steps. It's easy when we're looking at supply chain management and contract audits, it's easy to focus on your suppliers naturally, but also consider your contracts with your customers. Now, to the extent that those are contracts with customers based in the UK, there might be very little change. But if you're selling into the EU, then the position might be quite different. So it's certainly a factor worth assessing. And then once you've gone through the process of identifying all of the current contracts that the business has, also take a look at your own standard or template contracts that you'll be issuing going forward and apply the same sort of assessment to those as well. So that was stage one. You've got your list, you've got a sight of all the different contracts of the business. Now it's going to be impossible to look at them all at once. So the sensible thing to do is prioritize the review. And so prioritize those contracts that are more likely to be impacted. So for example, this might involve pulling out the contracts that are high value or strategically important. It might involve looking at the contracts where the counterparty is in the EEA or a country with a free trade agreement with the EEA. Long-term contracts would fall higher up the priority list, as are contracts which might be terminated by you or the other side in relation to Brexit or its impact. So for example, if you've already gone through the process of amending contracts to give you or the other side termination rights in the event that Brexit has particular effects, then they're going to be worth paying close attention to see whether those termination rights will be triggered. Similarly, situations where you're dependent on one or a very small number of suppliers who are vulnerable to Brexit, contracts in currencies other than sterling, probably unlikely, but any contracts that are reliant on EU grants or funding, and any contracts where there's a clear and obvious change in regulatory obligations, they would be the factors I think to take into account when deciding which contracts need to be higher up your priority list to review. So you've identified your contracts, you've got a priority list of the order in which you're going to tackle them. The next thing to do is then apply an assessment of risk. So look at all those issues that I just mentioned in terms of the general points, specific legal clauses, and figure out whether or not you need to do something, whether or not there is a risk, or whether or not it's absolutely fine for the contract to stay as it is. The final step, once you've done all that, would be essentially to consider what options you have to address any risks that you might have identified. There's a few different things that might be relevant here. So, for instance, consider whether you need to transfer to novate the contract to another group company, whether that's in the UK or indeed in the EEA. So naturally, this is only going to be relevant where you operate as a collection of group companies. But if you do you want, and is there a benefit to you in transferring that contract to one of the other companies in your group? If the answer is yes, look at the contract to figure out what you need to do that. So do you need the other party's consent? Can the other party terminate the contract if they don't agree with the transfer? If you can make a transfer, what period of notice do you need to give? Various factors to think about there. If not transferring, if not novating the contract, if the contract is a particular risk for you, it's going to be particularly difficult to perform after Brexit, it's worth looking at whether or not you can terminate it. So look at what the termination rights are under the contract. If you have a flexible ability to terminate for any reason, a termination for convenience clause, what notice do you need to give to trigger that? Or similarly, if the other party can terminate quite easily, what notice do they need to give you to do so? And also, what are the consequences of termination? So is compensation payable? Are any prepaid fees necessary to be reimbursed? Are there any exit services that need to be provided? And how might data might be migrated or dealt with on termination? And also, if you do have rights to terminate, it's also worth looking at whether or not there are any evidence requirements that you need to meet to rely on those rights. And finally, if not transferring, if not terminating, it might be that the contract just needs some changes to law or other references, as I mentioned earlier. And so you might simply need to amend it. And again, if that's the case, the contract itself will usually set out the process for how changes should be made. So whether you can do them yourself, whether the other party needs to agree, what the procedure needs to needs to look like to do that. So they were the risks to contracts and the issues that you might want to consider when carrying out a contract audit. I'm now just going to look at a few different areas where Brexit might have an impact. And the first one that we're going to look at is how Brexit might affect the package travel regulations. So the first thing to note here is that the PTRs will still remain in force in the UK at the end of the transition period. While the UK would be technically free to depart from them and make changes to the PTRs because we'd be no longer bound by the obligations coming down from Europe, I think it's very unlikely that we'll do so. As typically the UK government has always been at the forefront really of pushing for consumer protection in this area. So it'd be a big surprise if we essentially changed from that position quite significantly and started to roll back the consumer protections in this area. I don't think that'll happen. That said, there are two aspects of the PTRs which will operate differently post-Brexit. Now, the first of those is in relation to insolvency protection for sales by UK companies to consumers who are residing in the EEA. Now, under the 2015 Package Travel Directive, the European directive from which the package travel regulations came, package organisers are able to obtain insolvency protection in the EEA member state in which they're established and then rely on that means of insolvency protection when selling packages to consumers across the EEA. And this is known as the Mutual Recognition Scheme. And assuming that we don't reach a deal to the contrary before the end of the transition period, which again seems unlikely, the UK's role in the Mutual Recognition Scheme will come to an end on the expiry of the transition period. So what does this mean? Well, for those travel companies that are established in the UK and who sell to UK consumers, this will have little effect. However, if you currently rely on a UK means of insolvency protection to financially protect packages sold to EEA consumers, then this might prove problematic. So if you are a UK company selling packages into the EEA relying on a UK form of financial protection, you effectively have two options. The first option is to obtain a means of financial insolvency protection in each separate EEA country that you sell into. Or the second is to create a place of establishment in an EEA member state, obtain insolvency protection in that member state, and then once again, rely on that to sort of get back in the mutual recognition scheme and use that one form of financial protection for all of the sales. Now, option two sounds more attractive potentially there because it only involves obtaining one form of financial protection. But just note that the difficulty with that second option is that a place of establishment requires a real presence. So an office and people, the rules are clear that a mere post box address won't be enough. So a real footprint of some sort is required. So it might take quite a few measures to set up correctly. But either way, if you're affected, consideration will need to be given as to how you comply with those rules going forward. And then the second change to the PTRs affects agents who sell packages on behalf of package organisers who are outside the UK. So at the moment, Regulation 27 of the Package Travel Regulations imposes an obligation on agents who sell packages on behalf of organisers that are established outside the EEA. So if you're an agent and you simply sell a package which has been put together by a third-party organiser to customers in the UK, but that third-party organiser is based outside the EEA, Regulation 27 puts some obligations on your shoulders. And in short, Regulation 27 states that the agent must be able to evidence that the non-EEA organiser complies with the requirements of the package travel regulations relating to the performance of the package and the need to provide insolvency protection for the package. And if the agent is unable to evidence that the non-EEA organiser complies with those things, then they fall on the agent to meet instead. Now, upon a no-deal departure, or upon a departure unless there's a deal agreed to the contrary, which isn't currently looking likely, the rule will change. And instead of applying to agents that sell packages on behalf of non-EEA organisers, it will instead apply to an agent that sells a package on behalf of an organiser established outside of the UK. So any agent selling packages on behalf of a package organiser where that package organiser is not established in the UK will need to meet those Regulation 27 requirements instead. Now, the first of those obligations is unlikely to be problematic. If the organiser is established in the EEA, then they're likely to already be complying with the rules around performance and will have T's and C's in place that reflect that. But the second requirement is probably going to be a bit more tricky because it's not just that the EEA organiser has financial protection in place, they would need to have financial protection in place that meets the UK requirements. So if they don't have that, then as I say, the obligation would fall on the agent instead. So potentially a bit of a sting in the tail there for some agents at least. And then finally, I'm just going to really quickly take a look at the impact on data protection, because I'm running over my allotted time slightly. Data protection arrangements, and in particular transfers of personal data from EEA states to the UK, are one of the more immediate issues that needs to be addressed before the end of the transition period. So in terms of how things might change, data transfers from the UK to the EU, from the UK to the EU are likely to be fine. The UK government has indicated that these transfers can continue after Brexit without any additional protections being put in place. And that's because EEA states are deemed to have adequate levels of data protection in place for UK requirements, certainly. But the UK government has said that they're going to keep that position under review. It's data transfers from the UK to the EU that are likely to be more, from the EU to the UK that are likely to be more restricted. In a no-deal Brexit, the UK will, in any Brexit, the UK will become a third country under the GDPR, and controllers or processors based in the EEA will only be able to transfer personal data to the UK if certain conditions are met. So there's two conditions which are most likely to be relevant. One is where the EU Commission makes an adequacy decision about the UK, or two, that there are appropriate safeguards in place to protect those transfers instead. Now, we don't yet have an adequacy decision, and it looks very unlikely that we'll have one before the 1st of January. So it's going to instead be prudent to put appropriate safeguards in place to protect those transfers of data from the EU to the UK. So there's a couple of options you can take here. If you're making transfers of data between group companies, you can look at putting in place binding corporate rules. If it's transfers with a third party instead, though, you'll want to consider using standard contractual clauses and either amending your existing contracts to incorporate those clauses or separately agreeing them with the other party instead. Away from contracts, another point to consider is whether you need to appoint an EEA representative. If you don't have a base in the EEA, but you offer goods or services to individuals in the EEA, or if you monitor the behavior of people in the EEA, you'll probably need to appoint an EEA representative, I'm saying EEA far too many times, in an EEA state where you do business. And what that representative would do is effectively act on your behalf regarding EU, EEA, GDPR compliance and deal with any supervisory authorities or data subjects in that respect. And then finally, a more minor point, but one that's always worth looking at, I'd recommend reviewing your privacy policies too, just to make sure that if there's going to be any changes to your data flows, any changes to your transfer mechanisms, such as how transfers are protected, make sure your privacy policy is updated to reflect those. And that is everything that I had to say. Thank you very much.
Thanks, Luke. There was a fair few tongue twisters in there.
There really was. I struggled on that very last bit.
Well, thank you both for your presentations. We've got a number of questions to go through, but I mean, first of all, if I can just ask you both on a general question based on your experiences with your clients, how prepared do you think businesses are for Brexit? I mean, I think we're 35 days, 36 days away from it. Do you think there's going to be a last, mad rush to the end here?
Yes, from my side, I do. It's quite interesting. I think sort of if you took us back a year, I think businesses were sort of getting themselves in a position where actually, they were obviously very alive to this issue and were taking serious steps to comply with it. Then we got the delay in the form of the transition period. And more importantly, we got COVID as well. And I think those two things together have sort of really shifted focus away from Brexit as a factor. So yeah, we're seeing clients who aren't very far on in this process of sort of, all the points I mentioned earlier, our contract audits and things like that, and who probably do have a bit of work to do to make sure they're ready to meet the changing requirements after Brexit. So if anybody's watching this and feeling, oh no, I haven't done enough and I'm the only one, for what it's worth, you're not the only one. So I wouldn't worry about that, but I would start taking steps to look at it now, because as you say, we are very close to the end of the transition period.
Yeah, I would agree. I'd say the same thing, Chris. I think we're generally quite reactive as a sector anyway, and I think because there's all of what's gone on in the last 8 months, but even without that, there's a lot of just noise about the negotiation. And like I said, the reality is there isn't a big difference between deal and no deal for a lot of these points, but the temptation is to put it off until there is what's perceived as an outcome. So I echo Luke's point. I think as long as you get going, there's still time to fix it.
Thank you. And so we've had a few questions from our attendees. I mean, the first one I think you have predominantly answered, Luke, but just to kind of reinforce, the question is, what are the chances of PTRs not being brought across from the EU?
Well, zero chance, unfortunately. So there's sort of two things to look at here. There's what laws are already on the UK statute books, and in terms of laws that aren't on the UK statute books but apply directly from Europe, what's going to happen to those? And in both aspects, there's not really going to be any change. So the laws that are already on the statute book, and of which the package travel regulations is one of them, they'll continue to apply post-Brexit, post the end of the transition period. And even if that wasn't the case, come the day after, or come the end of the transition period, there's going to be something called, or used to be called, the Great Repeal Bill. I think they've changed the name since, which is effectively going to take all of the law that applied to the UK and came from the EU, but wasn't specifically on the UK statute book, and put it all onto the UK statute book. So it's going to do the exact opposite of what its colloquial title suggested it was going to do. It's not going to repeal anything. It's going to put it all onto the UK statute book. So yeah, anything that's in place now will very likely stay in place, at least for the immediate future. And as I said before, I don't see any real changes from the package travel regulations going forward, at least substantively.
Okay, thank you. And quite a specific question. So will there be any impact on an EU-owned business established and operated in the UK, but by an EU citizen?
So I don't think so. Is the short answer. It's not really my area, I must say. As I understand it, if you've already got a UK company set up, there won't be any changes to that. Your UK company will still exist and will still be able to operate. I think there might be some, depending on how that is set up and depending on how it works, there might be some changed filing requirements in terms of the information you need to provide to Companies House. But I'd recommend having a look at that and checking with Companies House as to what those changes might be. But certainly if you're an EU individual who already owns a UK business, a UK limited company, that that's not going to fall away. You're not going to be prevented from operating that come the end of the transition period.
Okay,
one of the things we see, Chris, is if depending on the size and depending on if that's an EU holding company that's holding the UK business, there are certain exemptions for things like preparing consolidated accounts, which will fall away. So the top company in the UK would have to prepare its own consolidation. Really, that if it's just a very simple structure, that might not be relevant. But there are a few little points like that you need to be aware of.
Okay, thank you. And we talked about if you're trading in the EU, you could potentially set up a business in a member state in order to comply with the legislation. Where and how can you establish a business in the EU? I mean, is there an easy tool to compare the different state requirements, the best one to choose? I mean, it seems to be the $64 million question, really.
I think it is. Martin, I don't know if you've got a sort of particular insight on this.
I think the first thing I'd say, even before you get to there, though, is established is the operative word, and established has a legal definition, and it isn't the case that you can just rent a WeWorks in Dublin and that's it, or stick a gold plate outside and offer. You have to actually have a presence there. You have to hold board meetings there. There's a whole series of things you have to do. So that is a challenge. It's not a quick fix. Ireland is the common one that we see people choosing just for obvious reasons. The language is helpful, but the Irish regulators are very clear on that point about you having to have a substantive business there. But I've not seen any tool where it's easy to compare side by side. I think to an extent it's led by the business and your operations. It depends on if you have a particular source market. We work with companies where they already have an infrastructure in Spain, and so that's an obvious place for them to establish, because meeting those definitions and having an office presence there is easy.
And does a company need to comply with the EU law if they predominantly sell to the UK, but occasionally an EU customer might book with them because they've seen their website?
Not necessarily. So it depends on really, I guess sort of the trigger is whether or not you're actively selling into an EEA or an EU country. I guess the best way to look at it is if you're a UK company, if you have a UK focused website that's all in pound sterling pricing, you only market to the UK, to UK consumers, and you don't take any steps to advertise or market your services to EU consumers, but it just so happens that an EU consumer comes along, finds your website, makes a booking with you, even though you've got, website language is in English, terms and conditions are in English, they've paid in pound sterling. if that's the scenario that unfolds, you're in a strong position to say, well, you've come to us. We haven't gone out to you. We haven't actively sold to you. So we can continue to comply with English law in the way that we do now for all of our UK consumers. But if you have any sort of notable number of sales to EU consumers, I would look at that point really very carefully, because I think it would be quite easy to fall foul of that. And so, for example, if you were using Google AdWords that were targeted at certain EU countries, or if you were using Facebook advertising that's similarly targeted or was allowed to target EU countries too, I think it'd be very easy to sort of fall foul and for a court to say, well, actually, you have actively sold into these countries, and so you should have followed their rules. But if not, purely UK focused, purely UK business, and a consumer just happens to come across you and make a booking, then you're in a stronger position to say that you shouldn't be having to comply with those EU laws.
Okay, and presumably you'd also need to check that in terms of insolvency protections, that those customers were still protected under the scheme with which you comply. So ABTA or ATOL, for example, I'm not sure ATOL would protect those customers.
Well, yeah, this is where it gets really interesting. There's some really technical arguments on that, because it's a difficult argument in some respects, because on one hand you're saying we're a UK business that's focused on UK consumers, so we're going to treat our consumers as if they were UK consumers and follow UK laws, in which case you could argue, well, you should financially protect them under your UK financial protection schemes. But if you look at the wording of the package travel regulations, for example, it applies to travel services that are sold or offered for sale in the UK. So there is an argument to make there to say that, well, we are complying with UK law and we don't have to financially protect an EU consumer, because UK law doesn't require us to protect EU consumers. Like I said, though, it is a very technical law, and I would strongly recommend technical arguments, and I would strongly recommend taking thorough advice on sort of the pros and cons of following those sorts of arguments and the risks that might come with them, if that's something you needed to consider.
Thank you. And Martin, are you seeing lots of companies, thinking about setting up, establishing some kind of presence in Europe?
Yeah, I wouldn't say lots, but the thinking is the easy bit. The establishing is probably not that hard either. The bit that is catching everybody out is the financial protection bit that underpins, this European lack of capacity, or the lack of capacity, is not just a UK issue. It is European. It's all across Europe. There's no bonding, no insurers willing to underwrite. So you could go and establish in Ireland. You could shift your senior team over there to base the office there. You could even get your license with CAR, the regulator over there. But it's, what do you use to fulfill that protection obligation? And that's where all roads lead back to some form of cash collateral product, whether it's cashback bond from a bank or a trust account. And actually, Ireland, I don't think, accept trust accounts. So really, it is some sort of cashback bonding structure. It's not easy. That's the bit that I think is going to catch everybody out, actually.
Yeah, absolutely. And I guess, that's where the impact of COVID has had a real, impact on Brexit and all the legislation.
I'm so sorry, just to interrupt and type in. It is also worth considering the other route. If you have sales to EEA consumers, it might actually be easier to get a form of financial protection in the different EEA states that you're selling to. Now, that's more likely to be the case where it's a small number of EEA states. So you're perhaps looking at one or two financial protection regimes, but rather than going through the process of setting up a place of establishment, it might just be worth looking at whether it's possible to get individual financial protection solutions instead.
Okay, thank you. And a lot of our discussion has been about the impact on businesses. Obviously, there's an impact on customers as well. Customers are obviously going to need advice on new passport requirements, on health issues, all that sort of thing. Is that something that tour operators have a responsibility to provide their customers with?
Arguably, yes. So there's particularly where you're selling packages. And I guess there's two things to bear into account here. There's what's your legal obligations, and there's what's just a commercially sensible thing to do from a customer satisfaction and avoiding complaints point of view. From that sort of sensible point of view, I think it's very wise to give your customers as much information as you possibly can about the different obligations they might have to meet. Because if something goes wrong, their first point of call is going to be with you. They're going to be on your phones. They're going to be raising issues with you. So if you can tackle any of that in advance, that's a sensible thing to do. But yes, arguably, where you're selling packages, there's arguably a legal obligation to do so anyway. because the package travel regulations require you to make certain information available to your customers, and some of that concerns information relating to visas, medical requirements, but that's not likely to change too much for humans, maybe for dogs and cats. But yes, you're likely going to be required by the PTRs to make that sort of information available to your customer anyway.
Okay. I mean, we've talked about a lot today, and there's obviously so much information to digest. I know, and both of you have talked about some useful tools to assist tour operators. So we'll make sure that those are obviously circulated to all the attendees on the webinar, and we will also be discussing about these issues probably over the next few weeks as well. But we are running over time a little bit, so I'm going to have to close it there. But thank you both so much for taking us through these issues. If anyone has a question that hasn't been answered, please feel free to email it through to Lucy, and we'll certainly get it answered outside of the webinar, particularly if it was around visas or employment issues. Thank you to our panelists and attendees for joining us. Our next webinar will be on the 10th of December, and we'll be turning our attention back to supporting you guys through COVID-19 related issues by providing advice on social media, currency, and by the sounds of it, Tom's. Details will be circulated early next week. But in the meantime, thank you all and have a good afternoon.